The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised. Welcome back to my little cubbyhole on the internet, everybody. Your favorite cubbyhole as well. Our cubbyhole is slowly growing in size yet again, thanks to the PR efforts of Dingus the Douche Canoe.
The fucking douche canoe.
It's been helpful. We've been growing leaps and bounds since all of that has happened. Thank you, David. You have given the boost my channel needed. What more could I ask for? Who could ask for anything more? Goes the song by Gershwin. But to get right into it, here we have Omar's declaration in support of the opposition to Gingras' motion to intervene, etc. I'm going to make this a hair smaller because it's driving me crazy. It's just a little too big. It's just big enough for you, hopefully. And of course, this starts in the usual fashion, declaring that he's licensed to practice in California, and it gets better in the next paragraph where we read, "The purpose of this declaration is to provide factual substantiation and authenticate evidentiary materials supporting respondents' opposition to David S. Gingras' motions to intervene, strike, seek sanctions, and request disciplinary referral." Ms. Owens obtained a temporary DVRO in 2018 that was extended by stipulation to July 10, 2020. In 2020, the DVRO was renewed over respondent's objection through July 10 of 25. On July 10 of 25, Ms. Owens sought a second renewal to make the order permanent. Respondent requested and obtained a multi-day evidentiary hearing. Attorney David S. Gingras was directly involved in matters affecting respondent, including the June 10, 24 courthouse incident in Arizona, which is now a disputed factual issue in this renewal. Based on my review of filings and Gingras' own description, he contacted law enforcement regarding respondent that day. Respondent contends this was improper. A bar complaint has been filed and a disciplinary investigation is pending. On August 15, 25, Gingras appeared for Owens, indicating to the judge he believed this hearing would take 15 minutes. I sought a long-cause evidentiary hearing, which the court granted. On August 18, 25, I participated in a 66-minute telephone call with David S. Gingras and Rachel Juarez. The 66-minute call. The purpose of the call was to discuss the case, including potential paths to resolution. It was expected that the call would take 5 to 10 minutes. Although the call began on those topics, it quickly became clear that resolving the case was being overshadowed. Gingras diverted the discussion to matters unrelated to the case, expressing opinions and grievances not pertinent to the issues. These included personal concerns and unrelated matters, without advancing any resolution relevant to our legal proceedings. During the call, Gingras stated, in sum and substance, that he wanted respondent's testimony, and that such testimony would aid his defense in a pending Arizona State Bar investigation into Gingras' conduct. When he made that point, startled by the audacity of the statement, I loudly exclaimed that there was a conflict of interest. Gingras was taken aback by the allegation. I had largely allowed him to speak while remaining quiet. He disagreed with my assessment. The request to collect respondent's testimony for his own defense could potentially compromise privilege or intimidate witnesses, thereby prejudicing my client's position in the process. I explained that Gingras is a precipient witness on contested matters, particularly the events surrounding June 10-24, and that his stated intent to obtain testimony he believes would assist his own disciplinary defense created a problem. Gingras disputed that any conflict existed. In substance, he said his interests were aligned with petitioners, that his prior actions were proper, and that client consent could address the Rule 37 issue. Regarding that representation at the time, prior to reaching the issue, I was uncertain whether client consent was a cure-all for a 37 issue, so I remained silent. At no point during the 66-minute call did Gingras say he had already withdrawn, nor did he commit to withdraw going forward. When the call ended, the status of his representation was that he would represent Laura Owens. In fact, we talked about the possibility of continuing the October trial to a later date. Gingras has been counsel for Owens in family law matters since March of 24, regarding the Maricopa County case referenced in the pleadings in this renewal, and we had spoken on August 14, 25 for 18 minutes and 16 seconds, where he indicated to me that he was going to represent Owens in these proceedings. Throughout the 66-minute call, Gingras spoke rapidly and at times digressed into personal matters, including references to his state bar exposure and DUI arrests. Well, now we know. It's about his problems, his Dewey and his bar referrals. There we go. It was difficult to keep him focused on relevant issues. Those digressions reinforced my concern that his personal situation had become intertwined with his role in this litigation. Based on that conversation, after consulting with respondent and co-counsel Rachel Juarez, we determined it was necessary to file the motion to disqualify David Gingras. On August 21-25, the motion had been drafted, and I was prepared to e-serve Gingras when I emailed him asking for permission to serve him electronically. He asked if I had time for a quick call, so I called him. He indicated he would not be representing Owens. We spoke for 16 minutes. I asked him to confirm that he was not representing Owens in writing, which he provided. Ordinarily, if opposing counsel orally represented that he would remain off the case, I would accept that and proceed accordingly. However, this was not an ordinary circumstance. These are undisputed facts, such as Gingras' behavior during the August 18-25 call, and the conflicts identified under Rules 1.7 and 3.7. These are factual observations. Based on these, I believed relying on an informal assurance that he would stay out of the case would not have been prudent or fair to the court or my client. The procedural risks, including the potential for an 11th hour continuance or even a mistrial under the rules of court, etc., which mandated a formal approach. There was no formal withdrawal on file when we spoke. No substitution of attorney had been executed. He represented that he tried to file the substitution of attorney into the case, which may have been rejected. What I had, at most, was an expression of intent that he did not plan to proceed as counsel. In light of the above factors, and given the approaching evidentiary hearing, I could not responsibly expose my client or the court to the risk of a last-minute re-entry or rolling dispute over Gingras' role on the eve of trial. I further anticipated that once Gingras read respondent's pleadings, which necessarily characterize disputed facts and contradict portions of his own prior sworn declaration, he would be triggered by those unflattering characterizations and feel compelled to re-enter the case to defend his own narrative. That concern was not speculative. It was based on A, his statements during the 66-minute call that he wanted respondent's testimony to aid his own bar defense, and B, his demonstrated tendency to personalize disputes and to respond publicly and aggressively when his conduct is criticized. We hoped Gingras would bow out gracefully. He did not. In my judgment, leaving the issue to inform assurances invited a yo-yo counsel scenario, re-entry when filings displeased him, followed by renewed conflict, objections, and delay. By filing the motion to disqualify, the court would be on notice that the issue was raised at the earliest possible time, that Owens would have time to obtain alternate counsel and avoid a situation where she asks the court to continue the hearing in October to obtain new counsel. We wanted the court to know this issue had been addressed in August, so it would not be a surprise if raised in October. For these reasons, out of caution, I filed the motion to disqualify. The goal was not to punish Gingras. It was to A, formalize what he had suggested informally, B, eliminate the conflict-driven risk of his reoccurrence as advocate where he is also a witness with personal disciplinary exposure, and C, preserve the integrity and appearance of fairness at the upcoming evidentiary hearing. In my view, based on what I personally heard and observed, relying on an oral assurance in this setting would have been imprudent and potentially prejudicial to both the court's management of the case and to my client's rights. I therefore sought a definitive ruling so that all participants would know who is and is not counsel, witnesses could be prepared without ethical entanglements, and the merits of petitioner's renewal request could be adjudicated without the collateral distraction of an advocate-witness conflict surfacing mid-hearing. My decision to proceed by motion was made in good faith after much discussion, driven by the unique facts surrounding Gingras' status, conduct, and conflicts. On September 12-25, Gingras, not a party, filed papers styled as an intervener, seeking to intervene, strike my disqualification motion, impose sanctions under CCP, and obtain a disciplinary referral against me. I did not receive a 21-day safe harbor service of any 128.5 or 7 sanctions motions before Gingras filed it. No such notice was served on me. Because the DVRO evidentiary hearing is imminent and Gingras' motions risked disruption, I requested that the court shorten time for hearing on his motion so they could be resolved beforehand. An expedited schedule would prevent last-minute motions from overwhelming the court and ensure the integrity of the DVRO hearing. By addressing motions in advance, the court is better equipped to manage its docket effectively and safeguard against procedural delays. The motion to intervene, along with all other relief requested, is deficient on its face and may be dismissed on procedural grounds without exploring the merits of the motion, although our opposition addresses the merits. Shortening time would allow the court to dispose of this side issue quickly, without muddying the waters of the issue at bar, the DVRO renewal. I operate a YouTube channel and have done so for several years, where I create content offering legal commentary on cases of public intrigue. There are 413 published videos on my channel, 18 of which were related to covering Laura Owens' family law cases and her upcoming criminal prosecution. The last of these videos was created on July 10, 2025. At that time, I had no professional affiliation with this case. I have not created case-related YouTube content since my appearance. I have not published any YouTube content about Owens or Gingras since I appeared as counsel in August 25. I do not control third-party creators and have not directed or coordinated their content. None of my videos contain threats of violence. Phrases like "want the smoke" are common slang used figuratively in legal commentary to mean "do you want the conflict challenge," not a literal threat of harm. Any thumbnail depicting a caricature of Gingras was satirical, meme style, and intended for comic relief. I have never threatened Gingras or Owens. It is my personal experience with Gingras that he often vigorously attacks anyone who opposes him, including Judge Mata, the Maricopa County judge who heard the Arizona case regarding Owens versus Eckerd, and his opposing counsel Greg Woodnick, whom he has gone out of his way to tell me personally that both of them have either broken the law or lied to the court or violated rules and should more or less be in jail. I've personally viewed David Gingras' created content attacking these individuals on his YouTube channel, although all that content has since been unpublished. Actually just unlisted. It's still there. Likely because he is under investigation by the Arizona State Bar. It stands to reason that I would not be insulated from those attacks. I personally observed posts on Mr. Gingras' firm blog and social media in which he boasted that YouTube approved his copyright strike against a small critic and celebrated the takedown with #JusticeForDingus. Previewed and teased his sanctions filing publicly, and then used his blog to accuse me of having straight up lied to the court, and to announce he would seek sanctions and a state bar referral against me. I personally viewed public postings indicating that Gingras sent threatening communications or demand letters to content creators Dave Neal and Megan Fox regarding their coverage of the Owens cases, and that he demanded that coverage cease or be altered. I can attach the relevant public posts videos as Exhibit C and D. These are not my communications. I observe them as part of monitoring the public discourse referenced in Gingras' filings. These items discussed above demonstrate that Gingras has been actively waging a personal online campaign against critics and against me, and that his motion practice here is consistent with that campaign. Based on these observed actions and consistent behavior patterns, it is my belief he filed this motion to stir controversy for the public that follows this case. He filed this motion not due to legitimate legal concerns. He filed it because he felt personally attacked. Gingras' attempt to introduce a Riverside matter, tentative ruling in Villegas v. Villanueva, as evidence of prior misrepresentations is confusing. The court expressly found no misrepresentation in its ruling on the Riverside matter. That was a motion to allow the filing of a cross-complaint that was supposed to be filed at the same time of answering the original complaint. Opposing counsel accused me of making intentionally false statements because the proposed cross-complaint was signed at the time of the motion for relief. The court rejected that premise, explaining why the accusation failed, and granted my motion. If helpful, I can produce the ruling on that matter, as I have a true and correct copy in my possession. I have never been found to have made a material misrepresentation of fact in any court, and that is signed under penalty of perjury by Omar Serrato, and that's also dated September 30, and, of course, filed slightly later. So that will conclude our Omar Serrato and Rachel Warwez entries into the DVRO back and forth. And we will get to Dingus the Douche Canoes in our next video. So stay tuned for that.